Hey, out there, legal warriors. Have you been subpoenaed as a witness to a court date? Do you want to know what to expect before, during, and even after court? If you're interested in the state of the law, stay tuned. This is the video for you. My name is Attorney Lance Fryrear. I'm a defense attorney in Lynnwood, Washington. My law firm's been defending people charged with crimes all throughout Washington State for more than 20 years, and I'm putting out these videos to help educate the public. So if you find this useful, please like and please subscribe. More people get the help they need. And I'm just going to jump right into it. I recently have been helping people that are subpoenaed to court as a witness. And when people get subpoenaed to court for a witness, as lawyers basically think it's no big deal. But guess what? I found out if someone is subpoenaed to court as a witness to that person subpoenaed, it is a pretty big deal. You might be anxious, you might be confused, you might want to know if you even have to go to court because we have other things to do. So in this video, I'm going to cover what to expect before, during, and after court. So before court, what to expect? Well, if you've been subpoenaed to court, that means you've been given some type of document, either in the mail or in person, telling you to go to a court date on a certain time, at a certain place, and obviously on a certain date to give evidence. Now, you might be subpoenaed by the prosecution in the criminal case. You might be subpoenaed by the defense in a criminal case, or you could be subpoenaed in a civil case. And I'm not here to talk about civil cases because I'm not a civil attorney. I'm a criminal defense attorney. But most of the time, you're going to get a subpoena from the prosecutor. It's going to tell you where to go and what to do. And if you have a subpoena from the prosecutor, I want you to look closely at the subpoena and make sure that you actually have to show up. Because sometimes there's instructions that the prosecutor wants you to call a certain phone number to see if the trial is even going to go. Because a little known secret is that the prosecutor has to subpoena their witnesses every time a trial date is set for every case they have, even though they know it's not likely to go to trial. And so when I used to be a prosecutor, which I was for 7 years, I would have a stack of subpoenas that I'd sign and sign and sign, knowing that the witness was never going to have to show up. So number one, make sure you look at that subpoena. This is what you should expect before court. See if there's anyone you're supposed to contact to find out if the jury trial is actually going or the motion is actually going on the date that it's supposed to, because almost always it's not. A case might get set for trial 1 time, 2 times, 10 times, which means 1 times, 2 times, 10 subpoenas you might get, which is really annoying, and it'll still probably never go to trial. But let's say you get a message, you learn that the case is going to trial. Well, now you need to ask the prosecutor or the defense, whoever's subpoenaing you, when do you actually need me? Because if it's a felony case, it may be a multiple day trial. And in a multiple day trial, you're not going to be needed on every day. If we ever watch trials on TV, stuff like that, or on YouTube, we could see that, it takes a day or 2 to select a jury. There's a whole bunch of witnesses. They're typically going to subpoena you for the first day of trial, even though you're not actually going to be needed then, most likely. So that's what to expect before court. Do you have to show up? Well, you're supposed to show up. In Washington State, if they can prove a material witness got the subpoena and they don't show up, the prosecutor has the option to have a material witness warrant issued to drag that person to court, put them in jail. Now, prosecutors don't normally do that, but they have that power. They don't have any proof that someone was served with subpoena, then it can be harder. So if you don't want to show up to court, you might want to talk to an attorney about what the possible consequences are to you for not showing up at court. But let's say we do show up to court when we're supposed to. What should we expect in court? And this is where people are the most nervous, and I really wish they were not. I've fought some cases trying to keep people from being forced to travel out of state to testify. And that made sense because it's pretty inconvenient to be forced to travel out of state to testify. But I remember thinking about a situation when, if we are a witness, how I would describe it is sort of the witness is in control. It's in control of what they say. And if you're asked a question in court and you answer the question, that's all you're really there to do. So I'll get into more of that later. But physically what happens is you'll probably be kept out of the courtroom if there's a trial going on until it's your time to testify, because typically witnesses that have not testified yet are not allowed to listen to the prior testimony of other witnesses, so it doesn't influence what they are going to say. Once it's time for you to testify. You'll be brought into the court. You may have seen it on TV. You'd get sworn in, promise to tell the truth, et cetera, et cetera. And then whoever subpoenaed you as the witness is the first person that gets to ask you questions. You're going to be sitting in a chair, and you're going to be asked questions. So in court, what you need to do is listen to the questions asked. And if you have an answer to the questions asked, then you answer the question that's asked. And after let's say it's the prosecutor who subpoenaed you, and then they get to ask you these non-leading questions, open-ended questions. And when they're done, then the defense side gets to cross-examine you. They can ask leading questions such as, isn't it true, Mr. Smith, that you didn't see my client drive? Isn't it true, Mrs. Smith, that you didn't see my client drink? So they're sort of suggesting the answer. That's a leading question. And you can do that on the defense. You're not supposed to do that on the prosecution side. Now, if you're a witness and you hear the other side object to the question, the court will tell you you should stop and not answer the question until the court rules on the objection. That's just a little tip if you're in court. And then once the other side, the defense side, is done in this example, then the prosecution gets one more chance to redirect or try to have you explain a little bit about the answers you might have given on the cross-examination. And when you're done, they excuse you, and then you get to leave the courtroom. But I'm not going to move on quite yet to what happens after court. I'm going to focus on the mindset that I want you to have in court. What I've learned from working with people subpoenaed as witnesses, they feel like they're responsible for the outcome of the action. They might have an interest to either try to get someone convicted, or maybe they don't want to have somebody be convicted in a criminal example. And that's a lot of burden, because you can't make an assumption as a witness how your testimony is going to be taken by the jury. You can't make an assumption as a witness about how the defense is going to use your testimony, or the prosecution is going to use or argue your testimony. And if you start to try to engineer in your head, slanting your answers to an outcome that you want, it can get pretty difficult on you. It causes a lot of anxiety, and it actually hurts your credibility. So when I think about if I was a witness, it's a very powerful position to be in. I would sort of think of it as some fun. And I know that's probably not how you feel watching this if you're subpoenaed as a witness. But to me, I'm the star of the show if I'm the witness. I can sit there, I can listen to the question, I can answer it to the best of my ability for what I remember at this time. It might be 2 years later. You might not remember anything. I don't remember is a legitimate answer if you don't remember. But if you just legitimately answer the question asked, each side is stuck with your answer, and what they do with your answer is up to them. It's not up to you. So there is no right answer. There is no wrong answer. There's just your answer. You're in charge. You are the person that's being asked to testify about what they know. Only you know what you know. No one else does. And any answer, as long as it's not a lie, is a fair answer. Now, if your answers are substantially different from what you said earlier, you could always think about talking to an attorney to see if you might get in trouble for perjury or making a false statement. And while those are legitimate threats, you almost never see that handled or prosecuted, but you still have rights, and so you may need to talk to an attorney. But if you go into court and you're subpoenaed as a witness, I want you to feel safe. I want you to feel in power as far as your answers go. There is no wrong answer if you're saying what is true to you at the time you're giving the answer. Please take that in. So moving on to what happens after court. Well, after court, you hopefully will be discharged as a witness. That's what you need to listen for. So you're done with the testifying. Your mind's probably spinning. You may not be listening that close, and you're going to hear somebody, prosecutor or defense, ask, Your Honor, can this witness be excused? And that's where we need to listen up. If the judge says, yes, you're excused, now you're done. Get out and leave. If you want to, you can stay typically and watch the proceedings since you're not going to testify anymore, but you have no further obligation to the court at that point. Now, if the court says, if someone says, no, I may want to recall this witness in rebuttal, now you're going to have to remain available for some period of time. That doesn't necessarily mean you have to stay in the courthouse. You could ask a judge, well, can I leave and then see if I need to come back, judge? But if you hear that, you're not fully discharged from the subpoena. But once you're fully discharged from the subpoena, you're done. They can't make you come back. Once you're discharged, you're discharged. They would have to give you a new subpoena to be able to force you to come back to court, at least in Washington state. So yes, it's scary to get subpoenaed as a witness. There's a lot of questions that we have when that happens. But the most important thing is I want you to realize it doesn't need to be scary because you're in charge, not anybody else. So I hope you found this useful. If so, please like and please subscribe. More people will get to see it. More people will get the help they need. More importantly, if you have a criminal matter in Washington State or you've been subpoenaed as a witness in Washington State and you think you need legal representation, feel free to reach out to my firm. We get on board, we'll listen to what happened, we'll identify a way forward, and we will be there for you. Thank you.